Hello, and thank you for joining us for the second episode of the Practical Patent Practice webinar series. This episode will discuss docketing formalities, restrictions, and non-final office actions. This is the second episode in a four-part series. The next episodes will be coming up in August and October. A recording of the webinar and the slides will be made available to all registrants. Feel free to enter any questions using the Q&A feature in the Zoom menu. They will be addressed in a Q&A session at the end of the webinar. We invite you to follow Black Hills IP and Schwegman, Lundberg, and Wissner on LinkedIn to see news about other upcoming webinars. And with that, I'll turn things over to our moderator.
Thank you, Michelle. Good morning, everybody, and thanks for joining us. I'd like to start off by introducing our panelists, but first, I'm Ann McCrackin. I am the president of Black Hills IP. I'm a patent attorney myself and also was a law professor at Franklin Pierce for several years. With me, I have three great people who are going to help me talk about U.S. docketing today, starting with Zhakalazky, Carrion. So Z, tell the audience a little bit about yourself, please.
Hi, all. Welcome to our second episode of this webinar series. My name is Zhakalazky Carrion, and some of you know me as Z. I've been at SLW for 16 years straight out of law school. Started as receptionist, then moved to case manager. A few years later, I moved to a few years later, I went to paralegal. Now I'm trying to forget what I've done at Schwegman. And then I finally landed in the docketing department, which I ended up finding my calling. So I've been managing the docketing department for almost 8 years. Hope you guys enjoy our webinar.
Thank you, Z. Adam, please introduce yourself.
Thanks, Ann. I'm an automation specialist at Black Hills IP. Before that, I worked as a doctor for Black Hills. And before that, I was in school.
Great. And Amanda.
Hi, my name is Amanda Loushin. I joined Black Hills IP in 2017, fresh out of school as well. And I started as a docketer before transitioning to a role as an automation specialist.
Great. Well, you know, as some people may know, our approach at Black Hills IP is to apply legal technology to traditional manual IP processes like paralegal work and docketing work. The future of legal operations really is going to be having people like Amanda and Adam, who are automation specialists in organizations that work to speed up various types of IP operations tasks. Docketing automation itself is something that I see that's going to specifically be a career path that people are getting into. Definitely at Black Hills, we have a large automation team, and I see other law firms that are starting automation groups or even spinning off technology groups to build AI tools and automation tools. So this is definitely going to be the trend in the future. And, you know, Z, I love your career path. That's a great story, how you got into docketing, and we're going to start to see other paths now for people in the IP legal space like Amanda and Adam going into automation specialist roles. So Adam, what does an automation specialist do? Can you explain that before we go on?
Sure. So in brief, an automation specialist designs and implements automated solutions to docketing problems. And what that entails is kind of a requirement for an understanding of docketing systems, automation systems, and how these all interact so as to design an airtight automated process.
Great. So your role, you tend to focus on the process of getting dates onto the docket, right? Or removing dates, the updating of the docketing system. And then Amanda, your role tends to focus on making sure that that work was done correctly, particularly when the updating of the docketing system was done by a human, right? So what we call verification more traditionally is called a second eye review or quality control. So you two bring different perspectives to the automation role as well. And that's going to be really interesting to hear as we go through this program. Okay, so Michelle, let's go to the next slide. The next slide is actually a polling question. I'd like to get a sense of who is in our audience and what the distribution is before we dive into the details of the program. So let's launch the first poll. And the question is, what is your primary role in your organization? If your role is not listed here, if you're going to select other, please put a note in the chat what other is, so I get a sense of just the different perspectives that people are bringing to this program. So we'll take a few seconds to give everybody a chance to answer the polling question, and then we'll see what those results are.
And we'll give the poll about 5 more seconds. And I'll end the polling. And here are the results.
All right, so the two biggest categories, about 2/3 of our audience are docketers and paralegals, which is what I'd expect, but quite a few people in the administrative role too. And I love a few of the comments in the chat that I am everything. I certainly know people in those kinds of roles too. So that's really helpful. Now let's do one more poll. Let's go to the next slide. I always find it interesting when we're talking about docketing to see what docketing systems people are using and what the distribution is. So let's launch this poll. What is the primary docketing system that you use? And with the Zoom webinar tool, we're limited to only 10 choices. And I know there's more than 10 docketing systems out there. So if other is your choice here, let's do the same thing and put that in the chat window and see what other systems I'm missing from this list. Okay. Let's give people another second or two and then we'll wrap up, Michelle.
Righty. So I will end the polling now.
All right, so CPI is the largest represented one here, but a lot of foundation IP as well. And CPI has been around for a long time. It's got a lot of organizations that use it. Number of AppCall and Anaqua. Then I also see in the chat window several docket tracks and Pendo, a few others on there. So good, that's really, really helpful. All right, let's go to the next slide, Michelle. My goal for today's program, or goals, I guess, are the following. I want to have something for everyone, regardless of your level of experience. If you're new to US docketing, you're on this program because you want to learn and have this as a how-to, then objectives 1 and 2 are for you. We're going to have in the slides images of the documents that we're talking about. We're not going to go through those in great detail line by line. We just don't have enough time in an hour program, but they'll be there and they'll be in your materials. You'll have the slides available to you that you can save and you can use as a reference. And we'll also be talking about what the specific deadlines are that need to be docketed for each of the documents that we present. So if you're here to learn, we've got you covered. If you're here because you're in that category of a manager or an administrator or an attorney, you know, in those instances, you're likely more thinking about the fact that you're responsible for the docketing operation. And we'll talk about process issues for you. We'll talk about common errors. We'll talk about how to avoid them. So there's a little bit in here for everybody. Michelle, let's go to the next slide. And just a real quick orientation, particularly for people who may be a little less experienced and they're here to learn. This is a quick overview of the patent prosecution process. Where we're focused today is that category right in the middle, examination. The first docketing webinar in this series that we did a couple of months ago, if you missed it, you might want to go and look at it. It talks about docketing for new application filings and priority applications and priority dates. Today's webinar is going to focus on documents in the examination process. There'll be another webinar in a couple of months that continues to look at the examination process and docketing documents at that stage. And then the fourth webinar in this series, which is about 4 months away, is on the post issuance type of docketing. So next slide, Michelle. All right, so for today's webinar, we're going to cover 3 categories of documents. We're really looking at the first part of the examination process, things that come up after an application is filed up to and through the first office action. That's the scope of what we're covering today. So I'm going to group this into 3 categories. One is official filing receipts and notices of publication. The second is formalities and formalities letters. And the third is office actions, and that's really specific to non-final office actions. We'll deal with final office actions in the next webinar. So next slide. Okay, for fun, for each of these categories, I have a song that helps me convey sort of the complexity and kind of the idea behind the categories that I've grouped these documents into. And I was inspired by Z on this because I was on a panel about docketing a couple weeks ago with Z, and she described automated docketing by reference to an MC Hammer song, Too Legit to Quit. I just loved that. I thought that was great. Nobody's ever used 80s rapper to describe automated docketing before. So that inspired me. I'm going to try to do it, and I can't do it as well as Z. But when I think about official filing receipts and notices of publication, I think about the song Easy by the Commodores. And I'll explain that in a couple of slides, but you can think about why I might have chosen that song and the lyric Easy like Sunday morning. It's a great way to think about it. So Z, can you walk us through official filing receipts and notices of publication?
Yes. So what we see is the official filing receipt. And whenever we're receiving these documents, you need to make sure that you're looking at the application number, the filing date, which is the most important part, because if it's the very first one, your foreign counterpart deadlines will be based off of that. And also you're seeing your inventors, and if this matter or application claims priority to another application. And this is also important because of potential foreign filing deadlines that you have to docket. And the title, to make sure that your title is correct and what type of entity status your application is. So as we can see here, we don't see a deadline docketed, right? We don't say, there's nothing here saying there's a due date here. Michelle, can we go to the next slide? So this next document is the notice of publication, and it's important because it's giving us the publication date and the publication number. So again, there's another document here that it's giving us information of the application, and there's no due date. But what is important is that you need to make sure that when you're reviewing your these documents, if there's any errors, you make sure that you correct them sooner rather than later. Next slide. So are there any deadlines to be docketed? The answer is no. But if there are any errors that need to be noted or corrected in your filing receipt, I would try to do that fast as soon as possible before your application gets published. So next slide.
All right, so there's not a lot of problems that come up with filing receipts and notices of publication. They're fairly easy to docket, and that's why I chose the song "Easy" for this group. There's no deadlines, like Z said, so they're pretty low risk. There's not a lot that you can mess up that would cause a liability for the firm. The main thing that comes to mind for me when I think about filing receipts is a process issue. And that's the amount of time that it takes to verify the data on the filing receipts. If you have a decent sized docket that you're managing, it can take quite a bit of time to do the filing receipt verification. And that is something that is often done by senior level docketers or experienced docketers, and it can really slow down your docketing process. So one of the things I'd like the managers on this program to think about is whether having your experienced docketers doing the verification of the data on your filing receipts is the best use of their time. Or maybe that's something that a different level person in the organization might do, or even look towards automating it. Certainly the data that needs to be checked is available in electronic formats, and it's fairly easy to automate checking things like filing dates, priority dates, titles, confirmation numbers, entity status, inventors, just to name a few things, are relatively easy to put an automated check in place. Adam, do you have any observations? Because I know you spent quite a bit of time developing the automated filing receipt checking process that we have. Any observations that come to mind for you on that?
I think you covered well kind of a lot of the fields that are important to verify and can be set up for automation. Really what you need is, what data you're comparing. So you need data either from the document or from pair, and you need data in the system that you're comparing it to, and then a process for what to do when there are any discrepancies.
Good. And I would assume you run into some obstacles, though, if formats of things like publication numbers vary. Is that an issue that comes up? Or PCT application numbers or things like that? Do those kinds of issues come up?
Yes, formats, when they vary, can be tricky. There are often ways you can build checks for that into your automation, but you need to be aware of them and take the steps to deal with them when they do arise.
And I want to pitch in a little bit, like having standard numbers or how you're putting the applications. It's super important because with PCTs, we encounter this when people are doing like PCT US 2021, or they and use the 6 last digits, or they do US 21 and then 5 last digits. Sometimes you won't be able to find that matter in the system or in the patent website. And then you're like, oh, well, it doesn't exist. When it does exist, you're just not entering the correct information. So having a standard number of how you're entering your information into your data, it is important. So
yeah, and that's a great tip. Oh, go ahead, Adam. Sorry.
Well, and just adding on to what Z says, one of the big benefits of automation is you can set up how the format for how to enter various dates or numbers to ensure the consistency you want.
Ah, interesting. Yeah, because certainly for anybody who's docketing manually in a docketing system and keying in those types of numbers, it's really important for an organization to have, if there's more than one person doing it, a standard or a guidelines document or something so that everybody's entering those numbers in a consistent format. or even, you know, if it's the same person, sometimes the same person can enter the numbers differently on different days, depending on the document they're looking at. You can sometimes just copy it off the document. So that's a key thing I'd say, is standardization of the data. Amanda, any other concerns that come up, particularly that you see from a verification standpoint with filing receipts and notices of publication?
Like you said, Anne, the filing receipts and the notices of publication are usually really dense with bibliographic information. So when that's being docketed manually, it can lead to typos being entered a lot of times. So we use our automated verification software just to double check all of those bibliographic fields. And then we also use the filing receipt as a cue to verify the important deadlines that would have launched off of the filing date and the priority date, such as the foreign filing deadline or the provisional conversion deadline.
Oh, that's a great point too, because in addition to checking the data that's just directly on the filing receipt, there's also key fields that launch off of some of those things like priority date and filing date. And those would be foreign filing deadlines, provisional conversion deadlines, and you can check to make sure those launched appropriately too. So those are great comments. Okay, well, those are some interesting things, but for the most part, I would say filing receipts and notices of publication are pretty easy. The things you need to focus on are more administrative in nature. Before we go to the next section, which is the formalities, let's take a pause and do another poll. I'm curious, so Michelle, let's go to the next slide and launch the poll. There's a lot of different models these days for how docketing operations are run. So I'm curious, who does the US docketing in your organization? Is it your internal docketing team? Do your paralegals do it? Maybe you don't have a docketing team and the paralegals do everything. Maybe you have an outside vendor that you're working with. Some companies have their own docketing system, but their outside counsel is the one updating their docketing system. Some small organizations might not even have an internal docket. Even some large ones might not have an internal docket if they rely on outside counsel. And again, if I didn't come up with your scenario here and you pick other, let's drop that in the chat so we can see what else might, what other circumstances we might have here.
And we'll give it about 5 more seconds. And I'll end polling.
Okay, so 50% of the audience has their own internal dedicated docketing team. Pretty high percentage, 27% of the audience has the docketing being done as part of their paralegal functions. 11% uses an outside vendor. And then we get into some smaller numbers. 3% have outside counsel updating their internal docketing system. 6% have no docket. And 3% are in the other category. So that's interesting. Okay, then let's, Michelle, move on and go to the next slide. Now we're moving into what I call formalities letters. The Patent Office notifies an applicant when there's a deficiency or an informality in a new application through various notices I'm going to call pre-exam notices. My song that comes to mind when I think about these formalities letters is the great Rolling Stones song, "Time Is on My Side." And I'll explain that in a few slides, but I'll let you think about why I might have picked "Time Is on My Side" for this group of documents. Z, can you walk us through some sample formalities letters?
So I'm going to zoom pretty quickly on these just for time purposes, but we are seeing right here a notice to file missing parts, okay? Back in the day, we used to get one notification and let us know what we needed to pay or formal documents needed to be resubmitted. Now we have different sets of documents. So next slide. The next document is a notice of insufficiency under 37 CFR 1492. And this one is documents that we received for a US application that was filed under 371. And you're seeing these boxes and we're seeing a 2-month due date and it's extendable. Next slide. The following one is notice to file corrected application papers. And usually this is because drawings or the specification needs to be corrected. Again, we're seeing here 2-month deadline and it's extendable. Next slide. And requirements for sequence listing. This is, again, regarding sequence listing. Something is missing in the application. It needs to be resubmitted. And we have 2 months and it's extendable. Next slide. What's in common of all of these 4 documents that we sent that you just saw is they all have a 2-month due date from the mail date of the notice received. And it's extendable for an additional of 5 months and a total of 7 months for you to reply. So all of these have the same wording and they're all extended under the provisions of 37 CFR 1.136A. Next slide.
All right, so I will admit that I have not read 37 CFR 1.136 probably since I took the patent bar many years ago. When I was more actively practicing and doing prosecution full time, I really didn't appreciate why some things had 5 months of extension, why some things had 3 months of extension. But it's all laid out in this rule. And if you understand this rule, it makes it really easy to know how to docket various things like the formalities letters and the office actions, because we'll see in a little bit that the office action text also refers to 37 CFR 1.136A for extensions of time as well. And there's more to this rule, but the part that's relevant for our discussion is just section A. So that's all that I've reproduced. And the key thing is this section A1. So when the document has a shortened time period for reply, that time period may be extended up to either the earlier of any maximum period set. And when there's a maximum period set, it's usually on the document, which we'll see in the office action examples coming up. Or if there's no maximum period set, or if there is no maximum period set, then the period for reply can be extended by up to 5 months. So that's why on these letters of formality, or these formalities letters that Z just walked through, all of them said a 2-month period for reply. They didn't have a maximum period set, and it said it's extendable under Rule 136. So those get the 5-month period for responding. Now, there's not a lot of things in the prosecution world where you have a total of 7 months available to respond. And that's why I chose the Time Is On My Side song for this series of documents. Okay, let's go to the next slide. All right, so what are some of the things that can go wrong when we're dealing with formalities letters and docketing formalities letters? Amanda, since you deal in the world of looking for mistakes, can you talk about some of the things that are common problems when you look at docketing for these different formalities types letters?
Yeah, some of the common problems that we see is that the docketer will enter the wrong activity action in the docketing system, or enter the wrong mail date as the base date for the response deadline to trigger off of, or just docket the document into the wrong matter entirely. So these things are very simple for our verification software to detect using the OCR from the document in combination with data from pair And we are usually checking to make sure the response deadline is properly docketed, as well as some standard checks that we do for most US documents, like verifying the application number, filing date, mailing date, and confirmation number.
Well, and most of these problems that you're checking for, really all these problems that we have listed here, are human errors, right? So these would come up when the docketing is being manually entered into a docketing system. That's where you have the risk of entering the wrong mailing date, entering the wrong or selecting the wrong action. These are all human errors, right?
Exactly.
And so the traditional way to prevent these problems is to have another human, a second eye review, a person, look over and do the double check. Other things, you know, are training, make sure you have good training. Also make sure you have good checklists. That's another thing you can do to prevent these things. But still, ultimately the best way to prevent these types of errors and to catch these kinds of errors is with automation. All right, let's go to the next slide. You know, there's another category of formalities that it's outside the scope of this program, but I just want to comment on briefly, and that's docketing of assignments and declarations. And quite honestly, we could spend a whole hour webinar talking about assignments and declarations, but for this program, we're focused on docketing the deadlines that are a result of documents that are generated by the PTO. But I do want to acknowledge the assignments and declarations as formalities too. Typically, these are soft deadlines. The law firms and the corporations that I work with all have different approaches to how they docket these. If I were to assign a song, I think I would use the Frank Sinatra "I Did It My Way" as the song for these, because there are a lot of different approaches. The best practice I would suggest is to docket an assignment and a declaration due for 2 months after the application filing if it's not filed with the application. And then if it's not filed within 2 months, don't remove that deadline, but either leave that deadline on as past due, or if you have a docketing system that automatically pushes that date forward, let it roll forward, but leave that deadline on the docket as a constant reminder. You know, there's alternative deadlines to docketing the filing of declarations. There's alternatives for docketing the filings of declarations and assignments as well, where you want to docket them prior to filing PCT or foreign applications, or prior to receiving a notice of allowance, or you know, the ultimate is you have to have the declaration filed by the time the issue fee is paid. And Z, did you have anything else on these in terms of dates that you might want to be aware of for declarations?
Yes, I do have a tip that's very important for U.S. applications that are filed under 35 U.S.C. 371. A declaration must be filed before RCE are filed after a 371 entry into the U.S., because otherwise the matter will be considered abandoned even if the application improperly goes into issue. So if an RCE is filed prior to declaration being filed, the application will automatically be considered as abandoned. And we learned that the wrong way. So just pay attention to that.
Well, thank you for sharing the things that you learned the hard way. Michelle, let's go to the next slide. So although assignments can be filed at any time and declarations technically aren't due until the issue fee, payment of the issue fee, I really encourage people to establish a practice of trying to docket and file these early rather than later. inventors sometimes become difficult to reach over time. Sometimes it's your later filed formalities documents can affect prosecution in foreign applications or priority claims. So there's a lot of good reasons to come up with your own practice to docket these early and try to get these taken care of early in the examination process. So I just encourage you to think about that. Okay. Before we move to the final section of the program, which is talking about office actions, which is where this really gets fun, I have one more polling question I'd like to break and do. So Michelle, let's go to the next slide and let's put up the next poll. All right, we've been talking a little bit about preventing errors and the role of automation and as a quality control measure. But I'm curious how people handle quality control right now. What I call quality control, or internally at Black Hills, we use the term verification. It's often what you call second eye review. So whatever you call it, how do you do that? Does your docketing team do that manually? Traditionally, that's one person dockets and a second person reviews. Do you have somebody else in the workflow responsible, maybe a paralegal or some other non-docketing staff that does the check? Or is it up to the attorneys to double check? Or maybe you don't have a second eye review process. Maybe it's all on the shoulders of that one person who's doing the docketing. Or if you have some other situation, again, beyond what I've got here, let's drop that into the chat window. Just curious to see what the quality processes are that our audience has, that they're using.
And we'll give the poll about 5 more seconds. And I'll end polling.
Okay, so this one's interesting. About a third of the audience has the docketing team doing the manual second eye review. Another approximately third of the audience has a different person in the organization, paralegal or some other staff do it. Very small percentage, 5%, have the attorney as the responsible. And this one's surprising. About a third of the audience, 33%, have no official process for a second eye review, which puts a lot of pressure on that person who's doing the initial docketing to get it correct. Okay, that's very interesting. Well, actually, before we go to the next slide, a couple of comments on this, because I find these processes very interesting. This is another thing to think about from a manager standpoint. How much time do you spend on the manual second eye review process? It tends to be a very resource intensive process, particularly if you're in the third of the audience that uses that first option where the docketing team does the manual second eye review. In that case, you essentially have a redundant process. You do the docketing process twice because the person doing the second eye review does everything that the initial docketer does other than type the information into the docketing system. They have to read the document. They have to determine what needs to be docketed. They have to go to the record in the docketing system. They have to look to see that the correct information was entered and the correct items launched. They're basically a redundant process. The problem with that is that 99% of the items that person looks at doesn't need to be reviewed because they were done correctly, hopefully, because they were done correctly the first time. So the ideal process would allow your reviewers' time to be spent just on the items that have some type of discrepancy or anomaly that might be an error, instead of repeating the docketing for the whole process for something that was most likely done right the first time. Now, that's why we automated the second eye review process at Black Hills, because this was such a resource intensive process. And the idea with our second eye review automation is that if we can, with 100% certainty, identify the items that were docketed correctly, and take those off the list for the person who's going to be doing the reviewing, and have our reviewers focus just on those things that need to have something looked at, then we're using our resources much more efficiently. So that was really a game changer for us when we started thinking about the quality control process that way. You know, if you're in the category of having the docketing team do the manual second eye review, I just encourage you to think about how much time that takes and really do some analysis on your process. You know, if you're in the category where you're the paralegal or the attorney does it, that's not bad if they're going to be looking at those documents anyway for some other part of their process. But, you know, how quickly are they doing that? Are they doing that right away, or is there some lag? And does that introduce some possibility for errors creeping into the process? And really, is that the way you want them spending their time or not as well? So those are all things to think about. All right, let's go on and now talk about office actions. So next slide, Michelle. All right. With office actions, well, the things that we've talked about so far are pretty straightforward, but office actions is where it starts to get interesting. Office actions are not as straightforward to docket as you would think. There's different initial periods for responding. There's different amounts of extensions available. For a human to docket an office action correctly, they have to look at a lot of things that are in the PTO document. And sometimes the things that they're looking for aren't even in the document that they would need to know to docket it correctly. So that's why I chose the U2 song. I still haven't found what I'm looking for, because some days I think the docketers feel like they've climbed the highest mountains, they've run through the fields, but they still haven't found what they're looking for to be able to docket something correctly. So Z, let's dig into these office actions.
So these can be tricky sometimes. If you get a non-final office action, a final office action, you're like, oh, this is easy, right? I got it. But when you have a first action interview, what we're seeing right now, and again, I'm going to zoom through these fast because of timing, but this first action interview, usually in that second page, we're going to be able to see what's the timeline that we have. And one of the things that Anne had mentioned prior of the extensions of time, this one is specifically telling us that we have 2 months from the mailing date of the document, and we also have 2 additional months, not 5 months. It's being very specific what we need, the timeline that we have. Next slide.
Yeah, and let me jump in on this one, Michelle, because we may have people on this program that aren't familiar with the first action interview program, but it's a really good program and I recommend it. It's been around for several years. In this program, an applicant can have an interview with the examiner, telephone interview with the examiner prior to the examiner doing the first office action on the merits. And if they do that, there's some unique docketing timing that comes up, and that's what Z just pointed out on this document. I'm not going to go into detail just because it's a little beyond the scope of this program, but I encourage you, if you haven't used this program as an attorney, it's a great way to try to get the examiner on the same page as you before that first office action comes out. If you're a docketer, these have to be docketed a little bit differently. Timelines are a little bit different, so you need to be watching for these. They aren't your standard run-of-the-mill office action. Okay, back to you, Z. So
next slide. And this is pretty much what I had already commented about the 2-month deadline, mailing from 2-month due date from the mailing date of the notification, and then extendable 2 months. And Tracy, I'm going to agree with you that the advisory actions can be confusing. So if you can join us for our next webinar, that's going to be awesome, because we're going to be giving tips about advisory action and final office actions and all that. So next slide. Here we have a restriction requirement. Before, a long time ago, it used to be a 1 month. Now we have 2 months. These two boxes that are in front of us is easy for us to figure out that it's a restriction requirement. We have a 2-month due date and extendable for 4 months. And then box 9 is checked to say that there was restriction. And then on the third page, you would also be able to see that restriction requirement. We need to do like elections of claims. So that's another way to figure it out. Next slide. We can go to the next one since I already mentioned this. Here we have an office action, a non-final office action that we're all used to seeing. So next slide. It says this action is made non-final, and we know that we have a deadline of 3 months, and it's extendable for an additional of 3, and we have a total of 6. So next slide. This one can be a little tricky because we have a non-final with restriction requirement, and you're going to be like, well, how do I know that this is it's a non-final office action with the restriction requirement if this is telling me the box 2B is saying that it's an action that is non-final, but box 3 is also checked. And let's go to the next slide. And also on page 3, it's saying election restriction. And Adam, how would your automation process catch this? Because if I was just seeing that second page, I would think that it's just a non-final office action because that box is checked to be.
Yeah, so automation would look at that checkbox 3, which you mentioned, as well as looking through the body of the action for text that indicates there's an election or restriction which requires a response.
Cool. Well,
you know, and Z, actually, I'm going to jump in. I have a real quick story that illustrates this quite well. We have a large firm that we work with that we do docketing for, and there's a few documents that they still want to docket themselves, and one of them is office actions with restriction requirements. Although we do all the other office actions, when it specifically has a restriction requirement, we send it back to them. And we're automatically docketing. We're using auto docketing to docket into their docketing system. So we had something that got sent back to them, and they sent us a question and said, why didn't you docket this? It's an office action. Looks like a standard office action, right? It's an office action. Turns out it was an office action with a restriction requirement. On our end, nobody had touched that document. We pulled it from PAIR. Our automated systems identified it correctly as an office action with a restriction requirement. And our automated systems followed the rules that we had programmed for this particular law firm that said, send it back to this email address. Black Hills isn't responsible for this type of document. So our systems got it right. They looked at it. They found this in the document. The funny thing is, the human on their end got it wrong, who's a very experienced doctor. I have a great deal of respect for her. She's great. But she looked at it quickly and she didn't pick up on the fact that there was a restriction requirement in here. So it's just a great example of the ability of automation to accurately detect and identify variations in these documents that are sometimes subtle and hard to find what you're looking for. But automation can easily find that and docket these things correctly and reliably. Okay, sorry, didn't mean to interrupt, Z.
Oh no, that was great. Great tip. So we can go to the next slide because this one, what you're saying, Ann, for me, I would be confused too, because it's giving me a 3-month due date and it's extended with 3 more months for extensions of time. But if you're thinking that it has restriction requirement, your head would be like, oh, why don't I have a 2-month due date? You know, why is it a 3-month? So what you mentioned is like perfect. And I'm happy that verification is catching this too. So next slide.
Okay, so there's a lot of things that I think can come up as problems when you're docketing these non-final office actions. And Amanda, maybe you can talk a little bit about that because you're in the spot where you're seeing what things our verification is flagging and finding when we look at non-final office action docketing?
Yeah, so a lot of the most common errors that we're seeing with these non-final rejections and the variants of them is the docketer failing to identify the correct period for the initial reply or the correct final deadline, not identifying that there's a restriction requirement or not being aware of the correct period of reply for that restriction requirement, and then failing to docket a supplemental IDS when there is a notice of reference cited included, which a lot of our customers want docketed. So verification can use a lot of the same data and technology that automation uses on the front end to catch these things on the back end when they are manually docketed.
Yeah, and your fourth bullet's really interesting there, Amanda, because it's not only making sure that the action for the office action got entered correctly with the correct due dates, but sometimes there's other actions that also need to be docketed. So you're docketing for a single document, the office action, you're often docketing more than one action in the docketing system. It might be the response due and a supplemental IDS due. And for the people that don't know the abbreviations here, it's SIDS is a supplemental IDS and NORC is a notice of references cited that comes with the office action. Sometimes we docketers speak in code, so it translates that a little bit. But sometimes you have multiple things to docket, and even that can be accounted for in automation, and it can be checked for with verification. Otherwise, your alternatives to that is, again, make sure you have good training, make sure you have good checklists, and potentially have the resources of some type of a second eye review looking for these things. All right, now there's a couple of other variations on non-final office actions that I think can be particularly tricky and interesting. So Michelle, let's go to the next slide. All right, the first one is the situation where you have a non-final rejection, but, and when you look at the document, it says the action is made non-final. So we can see checkbox 2B is checked saying this is a non-final office action. So that all looks good. The problem comes in when you get into the body of the office action. So Michelle, let's go to the next slide. You get to that conclusion paragraph and it says this action is made final. So what do? Michelle, let's go to the next slide. You know, for a non-final office action, your docketing due date's going to be 3 months from the mail date, and it's extendable by 3 months. But you know, the docketer doesn't know if this action is final or non-final. So, Adam, how do we deal with that?
So, I mean, you're spot on, Anne, that, you know, we don't know if it's final or non-final per se. What we can do is take this situation into account. We know this will come up from time to time, and per customer's preference, we can docket accordingly, whether that's, you know, we always want to docket these as final and note that, or whether we always want to docket these non-final and note that. We're flexible in that regard.
Yeah, so everybody in my experience has different, there's differing views on the right way to docket these. And from, you know, from the standpoint of quality, as an organization, if you have multiple people doing the docketing, it's important that your entire team is instructed on the same, on docketing it the same way, because consistency is extremely important in terms of the quality of your docketing. If it's being automated, you know, we don't care. We just need to know which way you want it docketed, and we'll program the system to docket it that way, and you'll get the standardization. But the key thing here is to have a standard practice for how you want the situation treated. And then from a verification standpoint, Amanda, I assume then that you can check for this kind of language as well, right?
Yep, that's correct. And we can adjust and customize the rules according to preference as well.
Cool. All right. We're getting close to the end of our program, but there's one more situation that I want to talk about. Next slide, Michelle. This is the situation for an office action that comes in on a case that's in the prioritized exam program. So, I think most people at this point know track one is a procedure for expedited review of a patent application. You have to pay a very hefty fee to get an application into that track one process. You're basically buying your way to get to the front of the line for the examiner to examine your office action quickly. The thing that's important for docketing, though, is to understand that once you have that track one status, there are certain things that can cause you to get kicked out of the track one program. You're still a pending application, you just go back in line. You lose your prioritized status. And one of those things is filing a petition for an extension of time. So when you have an office action on a matter that has a track one petition granted, so it's got the prioritized exam status, somehow you need to docket that in a way that the attorney knows that they can't take a extension of time or they're going to lose their track one status. So there's different ways to do that from a docketing standpoint. But typically people will docket the 3-month date as a final deadline, because you don't want somebody to see the 3-month date as a non-final deadline and assume that it's extendable and then lose their track one status. You don't want somebody or some firm that has a process of just rolling dates forward, if that's a non-final deadline, to inadvertently roll that date forward to the 4-month date, again, causing you to be in an extension period and lose your track one status. So those things are critical. The problem is when you look at this office action, there is nothing in the body of the office action or on this summary page, there is nothing in the 4 corners of this document that tells you as a docketer that this is a track one application. Now, what people traditionally do is maybe they have a custom status field in their docketing system where they indicate that it's prioritized. I've also seen people put something in the reference number of the law firm reference number to be a key to tell them, a code kind of, that it's prioritized. Even in the title as it's listed in the docketing system, I've seen that edited. But again, all these things, one, depend on somebody actually making sure they updated those things, a human doing that, and two, a docketer then having to make sure that they see that and they notice that and then they docket it correctly. So these are a real problem. Izzy, let's go to the, Michelle, let's go to the next slide. So how, Adam, can we docket things as, how can we use automation to recognize that we have a application that's in prioritized exam and make sure that's docketed correctly according to the way the customer wants it docketed?
So this is one of the coolest things I think we do, which is we can look at the pair history to determine that track one was granted and that nothing has been filed or issued subsequently that would have lost that status. And then our automated system can use that to make a determination of whether this should be docketed as a prioritized action or not.
Yeah, and I agree. I think this is one of the coolest things we do. I think this is really, really impressive. So, when we talk about non-final office actions, just as a category, we've looked at a lot of different variables. There's a lot of different things. There's a lot of complexity to it. But Adam, if you had been asked to pick the song for this section, thinking about docketing non-final office actions, would you have gone with the same song, I still haven't found what I'm looking for, or would you have picked something different?
Well, maybe I'd go back to the Commodores, Anne. I think these are very tricky documents, but automation can simplify that and make the determination easy.
Cool. That's pretty cool. Okay, next slide, Michelle. All right, so after today's program, you should be able to identify the common PTO documents that we've talked about, and these will be in your slides with all the images. You should understand what deadlines need to be docketed. You should be able to recognize the common manual docketing errors that can come up. And hopefully you can appreciate how automated docketing and verification can be used to avoid these errors. You know, docketing mistakes are the most common source of malpractice liability for IP firms. 80% of docketing errors are human errors in my experience. And automation is far superior to humans at detecting these kinds of anomalies and errors when they happen. So, you know, if the automated docketing is something of interest, we'd be happy to talk with you about that. We also are going to start offering our automated verification process as a standalone service in the future. If that's something you'd like to learn more about, we'd be happy to talk to you about that as well. And we have Jim Brophy's contact information, our sales guy, at the end of these slides. But, you know, let's take just a minute or two and see. I don't know if we have any questions. Nope, we don't have any questions. So given the time, I think what we will do is, Michelle, let's run through the next couple of slides real quick. I want to announce the next steps in the webinars. So in this series, which is on docketing, the next episode is on August 5th. And it will cover non-final office actions, appeals, basically the rest of the examination process. And then in October, we'll have the final episode, which will be the post-issuance deadlines. If you're interested in another series that we have going on right now in combination with SLW on digital transformation, there's still 2 more programs in that series. One of them is next Thursday. I'm on the panel next Thursday as well. One of the things that may be of interest to this audience is the discussion about automation for reference management and IDSs. There's a number of other things that are interesting on that program, but we'll be getting into IDSs and reference management. And then next slide. So finally, if you want contact information for Michelle at Schwegman or Jim Brophy at Black Hills, we've got their contact information here. We'll leave this up for a few seconds. And you know, if you have any feedback too, I'd love to have feedback because we have 2 more programs in this series. I hope this was useful, and hope you can join us for more of these programs. I'd like to thank Z and Adam and Amanda very much for being a part of this program. And, you know, thank you everybody for attending today. Have a great day.